Hello and welcome to SEO Daily. Day 5 of the hearings in the challenge to abrogation of Article 370 completed today. The court spent most of its time listening to arguments from senior advocate Zaffar Ahmad Shah, who is appearing for the Bar Association of Jammu and Kashmir and who is from the state himself. He contended that the autonomy of Jammu and Kashmir was decimated by the abrogation of Article 370. Shah argued that there was never a complete merger between Jammu and Kashmir and India. With special status which limited union interference, Jammu and Kashmir retained a significant part of its autonomy. When the presidential orders of 2019 abrogated Article 370, this autonomy, which was at the heart of the relationship between Jammu and Kashmir and India, was destroyed. Justices Khanna and Justice D.Y. Chandrachud quickly jumped in and corrected Shah's claims about India and Jammu and Kashmir never having merged as one. They reminded him that the state's integration to India was complete and the surrender of sovereignty to India was absolute. Article 370 simply imposed fetters on the exercise of the Union's powers on the states, like other states in India, which had a distinct lawmaking power under List 2. This did not mean that India's autonomy or its sovereignty was not absolute. Similarly, the limitations on the Union's lawmaking power in Jammu and Kashmir did not mean that Jammu and Kashmir was not integrated or merged with India. Shah explained that Jammu and Kashmir is distinct from these other states. In other states, the Union could make constitutional provisions applicable. But in Jammu and Kashmir, the concurrence of the state government is needed for the application of constitutional provision. This is because Jammu and Kashmir has a special, peculiar position which is rooted in its autonomy. Taking the court through various provisions of the Constitution of India that were made applicable to Jammu and Kashmir with exceptions and modifications, Shah argued that Jammu and Kashmir's power to accept these provisions only with these modifications was an exercise of its autonomy. He then moved on to the governor, whose concurrence was sought when passing Presidential Order CO 272. Article 31 of the J&K Constitution concerns the oath to be taken by the governor. It reads that the governor will preserve, protect, and defend the Constitution and the law, and binds the governor to devote himself to the service and well-being of the people of the state. Shah argued that by communicating concurrence to the passing of Presidential Order CO 272, the governor breached this oath and was liable to be impeached. In the last 20 minutes of the day's hearings, the court also heard arguments from senior advocate Rajiv Dhawan. His main contention was that the special status awarded to Jammu and Kashmir reflected diversity, which was a key feature of the Constitution of India. The Constitution is replete with promises made to the people, he said, with diversity being one among them. In the spirit of this promise, various states with diverse circumstances were taken into account with diverse legal frameworks governing them. So, all actions of the Parliament and any interpretation of the Constitution must keep this promise of diversity in mind. Article 370, Dhawan argued, was a manifestation of this diversity. This is why the President of India could only make laws for the state after consulting and getting concurrence from the state government. This was a way of consulting the diverse needs of the people of Jammu and Kashmir. Senior Advocate Rajiv Dhawan will continue his arguments next week on August 16, 2023. Visit seobserver.in for a detailed report on the day's hearings, and make sure to follow us on Twitter, where we give contextualized live updates. You can also subscribe to our daily WhatsApp updates. We promise not to spam you. We'll just start your day off with the most important update of the day at 9 a.m. sharp. Thank you for watching.